At 7:45, nobody likes to spend a lot of time thinking about their own deaths, but it is an inevitable part of life and one that requires some planning. We've got an expert on the subject with us this morning, estate planner and wealth advisor, Ernie Burns. Good morning. How you doing?
Good morning. Good.
All right, so this is something that, it's important to talk about. Obviously, as we said, no one likes to talk about it, but if you get it done the right way, then you don't have to necessarily worry about it anymore, right?
True. And for 29 years, that's what we've done. It's a big thing about having no will or no type of estate plan whatsoever. But if you don't, the state of Louisiana decides where the assets go. So minimum, you need to have a will, especially if you want to leave some assets to some heirs, or you want to take care of your spouse, or you might need some advanced estate planning.
Right. I guess I'd like to ask you, what are the consequences of not having a will if you have assets that you might be leaving behind?
Well, like I said, the state of Louisiana decides, and that means anybody can plead to court about getting assets, or you might owe them something, and there's no defense to your legacy. And your heirs or your spouse could lose assets they're supposed to inherit because you've never planned anything out.
So why is it when you have this plan, what sort of things can you plan out to ensure that things happen? Obviously, things typically go to the children, but you can plan across the board, right?
Yeah, you can, and a lot of times what's become very popular is a revocable living trust. Properly funded revocable living trust, your estate necessarily doesn't have to be complicated. You just want to make sure your assets go to your heirs and avoid all succession, and also dictate those assets in a manner that you wish. So therefore, if you have a child that is handicapped on healthcare needs, or if you just have several children that live out of state, and you don't want them to have the rigmarole coming back and traveling and trying to settle the estate with attorneys, a properly funded revocable living trust can save the state a lot of time, money, and aggravation.
And then make sure that your heirs get what you want them to get.
Yep.
We talk about a will, we talk about a trust. What's the difference between those two?
A will guarantees your assets will go to your heirs, okay? But you'll go through the succession probate system, which could take 9 months or a year or longer. A properly funded revocable living trust, the trust owns the assets, which is you. You're the trustee of the trust. But point of take is all the assets avoid all succession probate, so it speeds up the process, and it could dictate a little bit more detail than just a will, where the assets are going to.
What happens if you have neither and you pass? I mean, we talk about that in the beginning there. Here in Louisiana, I've always heard about the Napoleonic Code that sort of goes to the wife and then the children first. Is there a chance that your money goes, like you said, to debt collectors, to things like that?
A will can be challenged. I guess anything can be challenged. A will can be challenged and sometimes overturned. With a properly funded revocable living trust, it's more ironclad because upon your passing, it becomes irrevocable. And you can put a clause in the trust that if somebody challenges the trust, they disinherit themselves. So therefore, a properly funded revocable living trust with an elder law attorney is the most acceptable in a lot of areas.
And at the end of the day, it's better to get it done,
yeah,
and have that peace of mind.
Yes, because you're going to use one or the other.
All right, Ernie, thanks so much for joining us. We
Thank you.
Appreciate it.
Appreciate it.
Good tips. Time now,